we're feeding our own minds at the same time as we're feeding others. So Jeff, do you have the numbers for us this week, where we are with donations that Natalie's been told about, understanding that the donations are greatly in excess of that, I'm sure.
We sure do, Jean. Thank you very much. It's great to be part of the Will Work for Food project. Our audiences have been so generous over the past year. Our running total of contributions of which we are aware is $97,168. $97,168. So we're about to hit that magic $100,000 mark, and we so appreciate the generosity of all of you, those who are in a position to contribute to food banks. Thank you so much. Jean, back to you.
Thank you, Jeff. That's fantastic, and thank you, everyone. That's just thrilling. So, Jason, maybe this will be the week we go over the $100,000 mark. The challenge is up.
No pressure whatsoever.
All right, let me introduce Jason to everybody. Jason Harper is the founder of Harper Conflict Resolution, LLC. He specializes in education and employment mediation, utilizing a collaborative approach. In addition, Jason is an alternative dispute resolution consultant, a conflict management coach, an adjunct professor, and trainer. Most notably, Jason is the ADR consultant for the Los Angeles County Office of Education, providing mediation and conflict resolution services to over 50 school districts and charter schools. He is a lecturer in law at the University of Southern California, Gould School of Law, teaching on cross-cultural dispute resolution, and is an adjunct professor of mediation at Pacific Coast University School of Law. Jason has also provided mediation and conflict resolution trainings for organizations such as the Western Justice Center and the International Visitors Council, training adults from over 20 different countries. Jason has been recognized by the California State Senate and the United States Congress for his mediation trainings. Jason served as president of the Southern California Mediation Association, one of the largest associations of mediators in the United States. He is one of the founding directors of Kids Managing Conflict, a nonprofit dedicated to promoting conflict resolution programs for K to 12th grade students. Further, Jason serves as the vice president of MC3, a mediator certification organization that is professionalizing the field of mediation. And you may remember when he and Dr. Jack Getz spoke on MC3 recently in professionalization of mediation. Jason received his master's degree in negotiation, conflict resolution, and peace building from California State University, Dominguez Hills, and his mediation training from Loyola Law School in Los Angeles, my alma mater. So that's another good school there. Jason, the floor is yours, and we're so thrilled to have you with us today. Thank you.
No, thank you. Thank you so much for having me. Good morning, everyone. It's good to see some friendly faces, some familiar faces, and if not some familiar names. And so first off, a huge thank you to Jean, to Natalie, and to Jeff for having me. I greatly appreciate it. My second time around on the Will Work for Food program. And so this particular time, I'd like to highlight the Orange County Food Bank, the OC Food Bank. And Natalie, I believe you'll put the link in the chat for everyone to take a look at. But you know, I hope that everyone has been safe and healthy. Obviously, making it to 2021 has been no small feat for a number of reasons, least of which the pandemic. And so, you know, obviously in light of the pandemic, a lot of folks have had some food insecurity amidst other troubles. And so, you know, I appreciate programs like this that spotlight different ways to help people in a very, very rough time, you know, for everyone and especially for some. So the Orange County Food Bank is a food bank that I am promoting in this particular appearance on the Will Work for Food program, and I hope that you all find it in your hearts to take a look at them and possibly even donate. But even if you don't donate to the OC Food Bank, if you could donate to any food bank in your area or in other areas, I think it's a worthy cause for some people that are having a tough time. And so thank you very much for the opportunity to talk through that in particular. And so today I want to spend this time during the possibilities hour, as it is stated, to talk about a different type of a field for mediation, where mediation is necessary and useful and used. And so this is for folks that are, just entering into the mediation field, for those that are unaware, and for those that just remain curious about all the different possibilities. So today I'm going to talk about special education, and how mediation can fit into special ed, and how a mediator can fit into special ed and help out. So Jean did an amazing job introducing me. Thank you so much, Jean. And so I'd like to, use a PowerPoint slide to kind of talk through, all the different things that go into special education. So with that in mind, I'm going to share my screen, and bear with me. Thank you for your patience. So essentially what we're talking about is alternative dispute resolution. There's a lot there's a lot of different nomenclature when it comes to what it is that we do, depending on the field. And so for special education, it's called ADR. That's the big umbrella. And so I talk about it a little bit in the bio, but I'm going to go into a little bit more of that during our time together. So Jean gave a great intro, as I stated, but there are some other aspects to my background that really inform how I got into special education mediation. And so I want to take this time to really go through that. Obviously, I am an ADR consultant, and as it was said, I provide ADR services for over 50 school districts and charters in California and outside of California. As I said, I'm also a private mediator and a USC professor and president of SCMA, and all of those titles have been adventures all their own. Particularly my SCMA presidency. I was told a long time ago that educators make the best leaders, and the reason is very simple: the job description stays the same. Right? And the job description is you put your folks in the best position possible to succeed. And that's really what it's all about. But before all of that, in a whole other life, I was a 7th grade algebra teacher. And I will say it was, I loved it. I miss it. I still think about the kids. Obviously I wanted to go into other things, but that informs a lot of what I do. Even when I teach at USC Law, I still, approach it the same way that I approached, teaching 7th graders, because law students and 7th graders aren't too dissimilar. And the reason is because, law students, in my experience, project as though they know everything, but really they're just trying to figure it out amongst all the changes. So from that standpoint, not too far from 7th graders. And so obviously, and finally, what really informs me is I was what's called a paraeducator, which is someone who sits with a particular student in a special day class, which is a certain program within special education. And I'll get into that in a little while. So that kind of informs my journey into special ed mediation. It's a way of marrying my two loves, that being mediation and education. So now I want to give you some more context, some background knowledge, so you can have an understanding of what special ed is and how a mediator can intervene. So first, we have to start from the top. What is special education? And it's defined as a program that provides specialized instruction and or services for students with identified disabilities, giving them the opportunity to develop to their highest potential. Now, obviously, in the United States, in public education, special ed is delivered free of charge through a federal law, which is called the Individuals with Disabilities Education Act, or IDEA for short. And this is something that is obviously, you can research it, but it's a very, very, lengthy document that really outlines all the different things that students should have when they have one of 13 identified disabilities within the education system. Obviously, through IDEA, the provision of the specialized instruction and services is delivered through what's called the Individualized Education Plan, or the IEP. All right. Now, there's certain circles, and some become a little bit more narrow, right? So the first thing is the Americans with Disabilities Act, right? That's ADA. And that really speaks to meaningful access. Then from meaningful access, then it goes into IDEA, which then provides further protections for students with disabilities. And IDEA is essentially what we're working with here. And so from there, we talked about what special ed is, and now we're going to go a little bit further into what the IEP is. Now, the IEP, the Individualized Education Plan, is what's considered the roadmap for a child's education. And it specifies a number of different things. It specifies their eligibility, right? And by eligibility, I'm referring to what are the 13, one of the 13 disabilities that are recognized within education to receive special education services. Then it also talks about their present levels, right? By that meaning, where is a student at currently from a skills standpoint? What have they been working on, and things of the like. Then it goes into goals, right? Now, obviously, as I say, a little bit further, the goals are set out a year at a time. And so the goals talk about, the previous goals from the last year, if applicable, as well as, and really especially, what goals the student should have for development in the following year. Now, the goals generally speak about skill development that they want the child to be able to have or to be able to achieve within that 12-month period. Okay, so it talks about skills more so than anything else from a goal standpoint. And then what drives those goals are services. Now, based on the goals that are presented for the student, that everyone has input in, part of the IEP team, and I'll get into that in a second. Those services are a vehicle to help the student reach those goals in that year. And so that handles services. And then we go into accommodations or modifications. Accommodations are essentially what is it on a day-to-day basis that the student needs in order to be able to access the curriculum as well as they can, given the circumstances. All right. And so for some, it's preferential seating, right? They have to sit in the front of the class. For others, it would be, extra time on assignments and the like. And it goes down the list from there. Modifications are a little bit different. That refers to, the type of work that a student is working on, or an alternate grading system that moves away from what the state standards would be in a given circumstance or in a given place. As I said earlier, the IEP is set out a year at a time, and they have an IEP meeting that happens at least once a year. I say at least once a year for a reason. So you create your annual IEP, but the IEP also serves as a living document. So what does that mean? That means that during the course of that 12-month period, things pop up, things change, new developments arise. And because of that, what's going on in the IEP as it currently states may not be applicable, right? So we may need to meet again and have what's called an amendment IEP meeting, where we talk through any particular issues that are going on and make the necessary changes as they occur, right? So from that standpoint, the IEP is a living, breathing document that is subject to change at any point, but at least once a year, you want to be able to focus on what the eligibility is as far as what are one of the 13 disabilities recognized by the United States and education that the student qualifies for an IEP. We talk about the present levels, the goals, services, accommodations, and modifications. And there are other things that go into an IEP, but I want to make sure to give you the high points. And so the team, the IEP team, I've mentioned that a couple of times, it consists of a few folks. So you have obviously the parents, right? The executive producers of the child, as I like to call them. And you have the case carrier, and that's the person that essentially keeps tabs on the student's progress with all of their teachers, all their service providers, and essentially is that, person to, corral everyone and make sure that things are going well. Then you have the special education teacher, right? That's the one that's providing specialized academic instruction for the student. Then you also have the general education teacher, which is a person who can talk through where the student is in relation to their quote unquote typical peers. All right, that's where the general education teacher usually provides. And then you have the school administrator and any related service providers. Related service providers refers to any service that is related to the specialized academic instruction. So if a student has problems holding the pencil, which could really impact their access to the curriculum, you have what's called an occupational therapist who will work on different muscles so that they can grip the pencil in a particular way. That's one very small example of a related service provider. And so all of these people are here together as a team in order to work to the best interest of the student, and so that they can develop a program, or a plan rather, which is the IEP, that works to the student's benefit and creates a significant and comprehensive program for them for that calendar year. From there, we talk about what the problems are, right? I gave you the framework, the foundation of what special education is, going into what the IEP is. But once I noted also the members of the team, and that's a lot of people. And when you have a lot of people with a lot of different perspectives, conflict is going to arise. As we all know, as mediators and arbitrators and the like, conflict is inevitable, right? That's why it's called conflict management and not so much conflict prevention. But in this particular case, parents often disagree with the district or the local education agency about the special education services, what the student needs, and whether the student needs services at all. Now, that's just one example. There are other examples, the style of services, the delivery model. Should the student be assessed in other areas? And if they are, should they receive more services in light of those assessments? Do the assessments actually cover, educational based concerns or issues, or are they more universal? Those are the types of situations and conversations and conflicts really that take place within an IEP team. And so when it goes to a certain place, litigation in special education is called due process, which can be a fairly lengthy process where, whether the district or the LEA, the local education agency, files for due process, or the family files for due process. Things are, they go to what's called an administrative law judge and they make a ruling based on all of the evidence that is presented, much like, a lot of other forms of litigation. And so in that particular process, due process, that can translate to millions of dollars that are spent paying parents and lawyer fees. Now, why do I say paying parents and lawyer fees? The reason why I say that is because, in some cases, one of the things that parents will disagree about with a district is where a student is placed, as far as, the type of schooling, the type of class and the like. And so in some cases, parents will feel as though their students are not progressing well enough at the current setting. And so they'll make a decision to remove them and take them to a private school, or more private school where there's even more intensive attention taken, in regards to the student's disability, as it were. And in those situations, they're asking, as the offer of free and appropriate public education, that the district would pay for those particular services or that particular school. And so in those situations, if it is found that the district is liable to take care of that, then they would pay the parents and reimburse, whether it's reimbursing the parents or actually paying the school themselves, and as well as lawyer fees. And so, for example, in 2019, there's a large district in San Diego, the San Diego Unified School District. They spent, over $2 million in settling due process cases. Now, $2 million is, in the grand scheme of things, it's not a lot, but that's one school district in one state, right, in the United States. And so you can imagine, the type of settlements that are going on in special education throughout the country. And so, those are some of the problems when you reach conflict within special education. And so that's where mediators can come into play. And so, to kind of go into a little bit more of the characteristics of special education conflicts, there's a lot that goes into it. And I already see some hands up. And so what I'd like to do is, at the end of this, I'd love to, answer any questions that anyone has, obviously time permitting. and we'll cover it there. But let's talk about some of the characteristics of special education conflicts. The first is that it's a continuing relationship. Here's what I mean by that. Special education services start at age 3, and the student ages out of special education services through the education system at 22. Okay, so from age 3 to age 22. Now, as a former math teacher, by my count, that's 19 years. That's a 19-year-long relationship. That's longer than a lot of marriages nowadays. And in situations like that, you know, you're not always going to see eye to eye with the rest of the team. And there's moving parts, you know, people shift, and all of those things take place. But really what it's all about is, you know, the family isn't likely to move anytime soon. And the district, or the LEA, the local education agency, certainly isn't moving anytime soon. So we have almost a 2-decade-long staring contest, or a marriage, if you will, between a family and that school district. And in those situations, you can't necessarily treat this as a one-off business transaction, if you will, because, you know, when it comes to long-term relationships, the two ways that we generally approach conflict are through either coercion or avoidance. And neither work in this case for the exact same reason. And simply put, the reason is you have to see that person again the next day, right? So if I coerce you into a decision on Tuesday, you know, you're going to mess around and find out the shoe is on the other foot come Thursday, and people don't forget, right? Likewise, if you have an issue on Tuesday and you avoid it, you sidestep it, oh, well, you know, we'll just think about other things. Guess what's right back there the next day? The exact same issue. And so in these long-term relationships, we have to figure out a way to, you know, change the conversation and figure out a way to approach these conflicts in a way that allows us to be able to move forward and preserve the relationship, if you will. Now, obviously, there are some conflicts that need to go to that next step, but not all of them do. And you know, some of those conflicts, you know, everybody is still well within you know, federal law. However, it's some of those small discussions and small decisions within that can create that conflict. So that's the continuing relationship aspect. Another aspect is the context of the conflict. Now, the context meaning, you know, a lot of different factors, such as, you know, is a student in the 1st grade or in the 11th grade, right? Is it their initial IEP? Is it their very first one? Or is this, you know, their 8th IEP meeting? Is this, you know, a part 6 to a single IEP meeting? Or is it the first one out, right? That context matters within the confines of the conflict within special education. Another characteristic is that, you know, there are multiple players and personalities. Now, you know, there's the common joke that, you know, hopefully multiple players don't have multiple personalities. However, in a situation like this, you have a room full of people, in some cases up to 7, up to 10 different people who are all working towards the student's benefit, but they all have the same goal, but they see the road to get there just a little bit differently. And because of that, you take those particular differing ideas on top of the different personalities that they have, and one person's way of communicating may be completely different than another person's way. And that in and of itself can cause conflict. You know, I talk about, you know, cross-cultural communication in my USC class. And essentially what I tell them is everyone wants to put their best foot forward, but everyone has a different method of putting their best foot forward. And some of those methods are in complete conflict with one another. And that is what drives conflict. And so those multiple players and personalities can really exacerbate a conflict potentially within the special education system. And then finally, and this is, you know, the most important in my book, you know, one characteristic of the conflict is that it is emotional. And you know, this can be a little bit heavy, but I think it's necessary to talk about. And this is why a lot of empathy is needed in a field such as this. You know, obviously I like to focus on the positive and really celebrate the wins that a student has and the development that a student has. But this is something that was made aware to me after speaking with families, over the years, and I've had, thousands of cases, over the years. And so I've seen more than one family refer to the IEP itself, the IEP process, special education as a whole, as, at least a yearly reminder that their child is not what they were hoping when they found out they were pregnant. And, and obviously they're moving through, and they're working with their child, and they're trying to do the best that they can, but the fact remains is, there's a lot of emotion, there's a lot of grieving that takes place within the family, in a situation like this. To its extreme, I've heard multiple families refer to IEP meetings as quote unquote dream funerals, because essentially what they're hearing is, hey, this is where your typical student is, and this is where your child is, right? And what makes it even tougher is, the numbers to back it up, right? The graphs, the charts, all of those things. And for a lot of families, that can be a very, very tough conversation, especially in a situation where they're not seeing eye to eye on what the right move is, on what the right answer is in that moment. And again, not all families feel this way. A lot of families, they take their child and they love their child with all of their heart, and they celebrate their child, and they just lift them up as much as they can. But that is absolutely an issue within special education conflicts. And what happens is, or what I hope and what I try to instill into, families, as well as, education administrators and the like, is the empathy, right? The empathy that comes into this, when families are coming to the IEP meeting, understand that they're coming from a completely different perspective than the school district is in a lot of cases. And so, we have to be mindful of that emotional aspect as well. And that emotional aspect in light of, or in conjunction with, that continuing relationship, right? That 19-year-long relationship, we really have to be mindful of those things. And so when we look at all of these characteristics of the conflict within families, between families and districts in special education, you ask yourself, okay, with all of these conflicts and really the litigation that potentially takes place, that all is really a part of it. And actually, as an aside, when I talked about that statistic from 2019 in San Diego for special education, that $2 million, that was in 2019, which was, by all accounts, especially in light of the current situation, a regular year, right? A very nondescript year. Now let's take a look at what's happened in the past year plus in COVID, where a lot of school districts have completely gone to distance learning, which is where students are, sitting at home, firing up their computer and being instructed over the internet, right? Over whether it's Zoom, whether it's Google Classroom, whether it's WebEx, what have you. Students are having to learn that way. And because of that, there has been a lot of learning loss. There's been, the services that a student would normally receive with an IEP is a little bit different. And so instead of sitting one-on-one with the school psychologist to have the counseling sessions, it's done, over a screen. Instead of having occupational therapy where somebody comes in and works with you on your muscle development, those are done via screen and with somebody else, or usually more often than not with the family that's going over these things with the student. And so, the services are looking different, the delivery model is different. And because of that, there's an argument that some of those, there's learning loss, there's loss of skills, and how do we get that back? How do we recoup that? And so, this year and next year are going to be very, very interesting. Not to mention the long-term effects of, what COVID or what the pandemic has done to education, particularly in the United States. And so those are just some of the characteristics that are playing a role in the conflicts within special education. And so you're probably asking yourself, well, that's a lot of information, first off. But where does the mediator come in? What does that look like? Well, that's why I'm here, and that's why I want to talk with you about this. So it's called alternative dispute resolution services. You know, mediation isn't necessarily used until later on, but they call it ADR because there is a proactive and a reactive aspect to, you know, the level of intervention. I'm going to go into that particular spectrum of intervention in a second. But the ADR services, it's intended to provide individuals an opportunity to resolve their disagreements in a safe, positive, and efficient manner. Why safe, positive, and efficient? Well, safe because, you know, you want people to feel as though they can speak freely and talk through their concerns. It's positive because, again, we have a continuing relationship. And, you know, just because you had one meeting at this particular point doesn't mean that the next meeting isn't coming, right? The next meeting is going to come. And what about the communication in between meetings, right? We want to keep it positive because we want to maintain relationships. And it's efficient because there's the proactive side and as well as the reactive side. And hopefully the intervention that comes on the proactive side really negates anything that's reactive. And so from that standpoint, you hope that it's efficient. So with that in mind, allow me to go through all of the spectrum of intervention that a mediator can have within special education disputes. So we'll start from the top, right? Now, the conflicts can be parent-teacher conflicts, personnel issues within the district or the LEA, as it were. So we start from the top, and trainings. Trainings are absolutely a thing that you know, mediators can do. Obviously, you're trained in effective communication and in conflict resolution, and so you would bring that to the either admin or to the district personnel, faculty, and or staff. Then there's conflict coaching, going into IEP facilitation, and then informal and formal resolution sessions. And I'm going to go into each of those things right now. And I want to be mindful of the time because I see that there's a few comments and some questions as well. So obviously, as I mentioned, training is the earliest form of intervention, and it's the most broad, right? So what your hope is that, you know, when you're training people, when you're training either administrators or faculty or staff, you're giving them the skills that they can use, and maybe it's one statement within a training that they can bring into their next IEP meeting, and, you know, they can use it, and it actually mitigates a potential conflict that was going to come up. Right. And so you don't necessarily need to go any further. Things are settled right then and there in the meeting. And so, you know, the main topic is effective communication and conflict management strategies. That's usually the main thing that folks at school districts are trained on. And as a mediator, as a person that's gone through mediation training, it's important to understand that now you have certain communication and facilitation skills. And in doing so, and in using those and passing those on, you're now passing on those same skills to folks who are in meetings that have real stakes, right? And by the real stakes, I'm referring to a child's development. And it doesn't get much higher than that, to be honest with you. So that's the training aspect. Another thing that a mediator can provide in special education, conflict coaching, right? Conflict coaching is something where it's an intensive form of intervention where you're meeting with administration or faculty on a one-on-one basis, or maybe two-on-one, where you're meeting with either two or one administrator to talk about conflict management, either with a particular family for a specific case, and that could be project-based, or ongoing throughout the year. Sometimes administrators see that their team has a lot of conflict within itself outside of the parent, right? And so how do you handle that? Because this is the same team that's going to be around each other for, at the very least, this entire academic school year. And so how does an administrator handle and mitigate and manage the conflict within their own department, within their own staff? And that's something that a mediator can do because, again, we're trained in conflict. We're trained in conflict management, and it's important for us to be able to pass those skills on to folks that actually need it, and again, for the stakes that are in place in this particular field. All right. And then from there, it goes even further. There's another form of intervention, and that's an IEP facilitation. Now, I talked about the IEP meeting earlier, and that's the yearly discussion, at least yearly discussion that talks about the roadmap for a student's education plan. So, we talk about the present levels, the goals, the services, the accommodations, all of those things. All of those things are talked about in and decided in an IEP meeting. And in situations where, there's distrust amongst the team, because that happens, in a situation where, people get sidetracked very, very often, and so it doesn't lead to productive results or productive ends. Sometimes it's good for a facilitator to come in and try to guide that meeting. And for mediators, for those with mediation training, that's an excellent opportunity for you to use those mediation skills that you've learned and be able to apply that into the IEP meeting itself and create essentially a team building exercise within that discussion. And I say it's a team building exercise because as an IEP facilitator, you're not necessarily a member of the IEP team, but your mission, your job in that particular meeting is to get the other members, to get the members of the IEP team to understand what the common objective is and to work together in a positive communication standpoint, from a positive communication standpoint towards the best interest of the student in developing this plan in the best interest of the student. Now, IEP facilitation is the most used intervention in the spectrum of all the things that I talk about. And from a proactive conflict management standpoint, proactive by way of the training or the conflict coaching, as well as IEP facilitation, this is the most effective form. And why is that? Because in the other forms, you're dealing with only one side or one particular person within the IEP team. In this particular aspect, you're working with everybody, the parents included. And in those situations, you are trying to plant the seeds for better relationships, not just for this meeting, but for the next 5. Okay. You're trying to teach them, through example, through your own communication, how to effectively communicate moving forward. All right. And then from there, this is where you get to the reactive side, and that is resolution sessions. When there is disagreement at the IEP level between the family and the district, what typically happens is, a resolution session happens either just before someone files for due process or immediately after. And typically attorneys are not present for resolution sessions that are pre-due process filing, but absolutely for post-due process filing, because the families have retained counsel. And really for a mediator, this is where you're actually using your mediation skills in a mediation. That's the resolution session is another term for mediation. And in those situations, your job description stays the same. You are mediating a dispute between the family and the district in regards to, insert particular issue here. And so it's before filing, it's a last ditch opportunity to salvage the relationship between the family and the district. The reason why I say that is because when the due process is complaint is filed, whether the district or the LEA files it or the family files it, once that happens, the relationship between the family and the district changes to a certain extent. And now we've gone through a totally different process while still being attached to each other for the next umpteen years. Okay. And so the communication is going to look a little bit different. And so it's important in the resolution sessions that are pre-due process filing to try to, within that mediation, to try to salvage that relationship, because we all know that, the relationship does change once the due process complaint is filed and we're going into litigation. Now, once everyone is in litigation and you are mediating that resolution session, it's still important to try to salvage that relationship. And there are certain ways that you can do that. And one story I'll share briefly was a mediation that I did for a district and a family. The family had filed because they felt as though the psychological services that the student was getting was inadequate. And really, there was a lot of back and forth, and there was a lot of emotion that was tied into that particular dispute. And so, to go into some of the items as to why conflict arises, I was able to, at a certain point, I got all parties into caucus. and I'm sitting with the family and their attorney, their counsel, and I'm talking through, just kind of the background, the backstory that got us to where we are currently, or where we were, and really the family at a certain point said, honestly, you know what it really comes down to? I didn't like the way the psychologist talked to me this one day. And based on that conversation or that brief interaction, it just went in a downward spiral from there. And I heard that, and it was a kind of a bold move, but I asked if they'd be willing to have a moment with that psychologist, if I could get them there. And she said, yeah, absolutely. The family said yes. And so I was able to, get the psychologist to come in, and they had a conversation about that particular moment. And, it was really a misunderstanding. And what ended up happening was they were able to clarify what was missed in that moment. And from there, the causes of action just started to just melt away a little bit. And things started to thaw out. And so what happened was, this is a student that was going to be with that district for a long time, right? The student was in the third grade. And again, I said, the special ed services go to age 22. And so in that situation, the psychologist and the family were able to, kind of reestablish their relationship. And the settlement agreement went from, a bunch of things to very, very little, and people walked away happy. And more so than the settlement agreement, and that's fine, but the relationship was able to be maintained and pushed forward in a positive direction from there on out. And so, that's one of the things that's really important during these resolution sessions, to be mindful of the relationship, even as you're talking through the numbers. And so with that in mind, that pretty much, goes over, all the different ways that a mediator can intervene in special education conflicts. And I gave you a lot of information in a very short amount of time, but hopefully it brought to light a few things that mediators can be and that they can do. This is the possibilities hour after all. And so in those situations, a mediator can be a huge, huge benefit to a school district, a family, a community, when it comes to the relationships within special education and within education as a whole, because this is the most vulnerable part of our population. And to be able to do things for them, to be able to create the space where relationships can be mended and strengthened, is a huge benefit. So you're probably asking yourself, well, what do I need to do in order to, go into this? Well, there are some skills that you need. There are some other things that you can do, but obviously you need mediation skills, right? And anyone that's gone through most mediation training programs has those base amount of skills. From there, you should also have facilitation skills, right? And so, most mediation trainings teach from a facilitative format or facilitative standpoint. So, using those skills and then building on them, right? You're not just the product of one particular mediation training. You're the product of, a number of instructional hours and skills. And that's important in building your confidence as a mediator, as a facilitator. And obviously you're going to improve on your active listening skills, which is absolutely important, because not only are you using that, but you're also modeling it. And that's why it's so important to use those active listening skills. And the last one, and this one is very important, subject matter expertise is absolutely imperative. It's one thing to really talk through and harp on the relationship between families and districts, but without that technical knowledge, it's going to ring a little bit hollow. And so what I would recommend, if you are a new mediator coming into the field, or if you are a person that is, coming from one career into the next, and that may be special education, I implore you, read up on IDEA, go to different districts have what's called community advisory council meetings, where families are coming in and talking about some of the issues that are going on or how districts are handling certain services. Sit in some of those. Read up on all that you can on special education. particularly in your state, because different states have different ways of providing special education services. So have an understanding of those things. And then when you get to the IEP meeting, when you get to the resolution session, you're able to speak to the district as well as the families on a completely different level than just a facilitative relationship-based conversation. While that is important, that is only part of the process. So those are the things that I would recommend that you be mindful of and be aware of, particularly when it comes to special education. And because, again, as I said, this is the most vulnerable part of the population, and to be able to, provide your skills in this particular way can have huge benefits. If you have any questions, I'm willing to take them now, but this is my email address. If you want to reach out to me privately, feel free. But at this time, I'd love to take any questions you may have, and let's do it. Thank you all again for the time.
Well, thank you so much, Jason. This has been great. And you do have wonderful comments and questions in the chat. Let's see, is Jeff still here? I can't see him on my screen. Okay, well, he had to leave early. He had something that he had to do. So I guess he's already left, but unless you speak up, Jeff. All right. Well, one thing before we get into more of the earlier questions on this is, there is a question, I think, that from where you left off, Jason, about, what would happen with mediation and all, is the next step, the ultimate trial setting. And one of the questions here is, Jason, I'm the father of a now 25-year-old severely disabled son. And until the age of 22, we grappled yearly and sometimes more often in IEPs and in due process with the LAUSD over his specific educational needs. One year, we even went to trial over those needs and on an issue which the trial judge was able to convince the district to concede then in the middle of trial. And then he concludes with, it would be helpful if you could describe the ultimate trial setting and process as the end of the administrative struggle with the school districts. Just something real briefly, because that's kind of the whole parameter. And then we can go back onto more of the mediation types of questions.
Yeah, so essentially the question was, what would be the ideal trial? Was that the question?
If you can describe the ultimate trial setting and process as the end of the administrative struggle with the school districts.
Oh, wow. Oh gosh. We're talking about the end of the administrative struggle. So that's a heavy question. I'm not sure I can even answer that, because the different scenarios are so different because of all the different issues. And so for that particular question, I'd want to hear a little bit more about their specific experience to really be able to really answer that, succinctly. So I'm sorry, I wouldn't be able to answer that. I guess I'll use the 2-word answer, that is tried and true amongst a lot of mediation questions with, it depends. I'll say that.
Well, just in general, it's going to go to a trial. Is that it? If they don't resolve everything. And is that a trial in the regular courthouse?
No. It's what happens is there's testimony, there's and all of this is done in front of an administrative law judge, and the ALJ at that point will give a ruling based on the different complaints that are filed, and so this is so for out of 10 complaints, out of 10 particular issues, the judge will rule on each one, right? And so it's not necessarily a whole, well, you're guilty all the way outright. No, on some items, the district is found liable to not have provided a free and appropriate public education. In other situations, the district was found to provide free and appropriate public education. And so in those situations, it depends on what the actual complaint is, and that's typically how it goes.
Okay, great. Well, you guys can connect later and talk more on that if you want. Thank you. So here's another one. Another question is, I'm a family mediator, special education parent advocate. I'm curious to hear your thoughts on the conflict between parents seeking needed services for their child and districts faced with budget constraints. What's your strategy for resolving these disputes without tremendous delay and expense, which may ultimately negatively impact the child?
Absolutely, and that's an issue that comes up quite a bit. When we talk about budget constraints, obviously it is unlawful for school districts to deny a service based off of cost, right? That's one of the railings that you can't touch. And so from that standpoint, one of the things that I think is important is talking with both parties on, okay, is there any way that you can try to replicate that particular service or that particular placement? And sometimes they are able to, and that's one of the things that's really a benefit when I'm facilitating IEP meetings. Sometimes we can go and think outside the box. A lot of times with a lot of IEP teams, they're stuck in a very rote routine method, and their minds just are just on one track and thinking about just the small box that they view special ed in, and they don't see beyond their own process. And so that's one of the things that's great about what it is that I and other mediators do in special education, which is try to come in and have those conversations and say, hey, I understand this particular issue, but have you considered getting creative? What does creative look like? Let's brainstorm. Let's just take all the fancy stuff and the formal stuff off, and let's just really think it through just on a human level. Let's just think about it. And a lot of times it's resulted in a creative setup that no one had thought of before, or maybe it was in bits and pieces, but no one had put it together. And so that's a situation where it's great to have a mediator come in and a fresh set of eyes to be able to try to resolve it.
Okay, great. Thank you. We've only got such a short, we only got about 6 or 7 minutes left. So let's see how many more we can get through. How do you approach least restrictive environment when clinicians and parents know a certain program is the needed accommodation, but the district feels compelled to try some lesser remedy first, even though the team really thinks it's going to only delay the progress?
Well, I mean, obviously IEPs are team decisions, right? It's all based on a team discussion and team decisions. And so, if the majority feels as though, a particular setup is more appropriate, the idea of least restrictive environment, and let me just back up. So the least restrictive environment refers to a student being as close to general education as possible, right? So general education is generally the goal for a lot of students to be in a general education classroom with, as little supports as needed, right? Because they want to simulate the gen ed experience as much as possible. So least restrictive environment is all the different ways that we can stay as close as possible to the general education experience. And so, with that, you come different stages and different placements, whether it's, gen ed environment with supports, or gen ed environment and pulling out or taking the child out of the gen ed class to get other supports and then to come back in, or vice versa, and down the line all the way to the student is in a completely different class with a completely different teacher and completely different students. And so, when there's an issue and we talk about least restrictive environment, yeah, some members of the IEP team will say, hey, well, I think that they would probably be best in this particular environment, in this particular setting. And others who talk through least restrictive environments say, okay, well, I understand that, but that's pretty restrictive. That's probably taking the student further away from the gen ed peers. Let's see exactly how close we can get to the gen ed peers in a certain instance. And in those situations, again, it's a team discussion, and that's one of the things that a mediator is good at, for trying to build consensus and talk through all the different angles in a decision like that, because it's not an easy decision in a lot of cases.
I'm sure it's not. Kristen here is wondering, do you talk about specific tools and techniques for special ed mediation sessions between parents and school districts?
Yeah, so specific tools and techniques. There's a toolbox. Just like any other mediation, there's a toolbox and a range of skills and techniques that are applicable depending on the situation. And so I would never I would never go so far as to say that there's a one-size-fits-all strategy that you go into either an IEP facilitation with or a resolution session with. You have to be mindful of the audience. You have to be mindful of, by the audience, I mean the parents and the family and the district, and what their communication style is and what their philosophies are and all of those things. And I think that's really the skill, being flexible. That's the main skill that I would use.
Sounds great. There's so many wonderful comments here in the chat. Everybody's been able to see them. Jason, you'll be able to see them afterwards. We can send them to you.
Well, I'm seeing some real experts in the house today. We've got Richard Earhart, who's here, who is actually, if I may, Richard Earhart is a former administrator in education, and he does he's done special ed mediation as well. And so I like to acknowledge Richard Earhart and all of the other folks that are here. This is a great crowd.
It is. It's a real specialized crowd, and it's so wonderful to have everyone here. So we're getting close to the top of the hour. I would say, Jason, thank you so much. This has been fascinating and so instructive and so beneficial. This has been streaming live on YouTube and will be posted and available for watching later, both on the willworkforfood.news website and LinkedIn. And then Jason, as he gave everybody his email address, if anybody has any further questions. So unless you have anything more, Jason, I would say that it's a wrap.
Well, thank you again very much to Natalie, to Jean, and to Jeff for having me once again. And again, the Orange County Food Bank would be the food bank of du jour of the day. And so if you feel so inclined, feel free to look them up and to donate. But if not, donate to a local food bank close to you, because it's a great thing to do.
It's a wonderful thing to do. So thank you, everybody, for your generosity. It's great to see you this morning. For me, the morning. Good evening for you, maybe elsewhere in the world. And we'll look forward to seeing you next Thursday, 8 a.m. Pacific, at the Will Work for Food presentation. So thank you, and thank you again, Jason. Thank you all. Bye-bye.
Bye, everyone.
That was great. Thank you.
Thanks. I had a good time.
We're still live. Actually, we're still live on